Hello, everyone. How's it going? This is Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration, to see the questions that you may have on your mind today. Thank you so much for joining me. My name is Moumita Rahman, and I am an immigration attorney. I have been practicing immigration law for the past 14 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So if you are joining me for the first time, thank you for your presence. Thank you for being brave, and feel free to go ahead and put in your question about immigration in general or about your case, and I'll do my best to answer as many questions live that I can in the time that I have today. So something that I do want to start out by talking about immediately is, can you still file for VAWA, a self-petition, if your original marriage case was already denied? Meaning, in other words, if you already tried to get a green card with your husband or with your wife, but that case got denied, and you also suffered in your marriage, and maybe that was actually one of the reasons why your case got denied, can you still find relief and get a green card by yourself by filing a self-petition? And the answer is yes, it may still be possible. Now let's go over what are some of the reasons why your marriage case may have gotten denied, even though you have a real marriage, even though it was not a fake marriage and you did everything that you could to get approved. Number one, some things that I have seen in marriage cases is where you might be married to a U.S. citizen or to a green card holder who does not tell you the truth. Now, if your spouse, you find yourself, sometimes you might be at the immigration interview and you find out at the immigration interview that your spouse was actually married before, or that they have filed for other people, or that they've been arrested for something, or you might even find out at your interview that your spouse has like this crazy debt history and all these things. All these things come to light at your immigration interview. Now, if you are finding out these things about your husband or about your wife at the time of your interview, the chances are pretty high that your spouse has lied to you on purpose in order to hide the truth from you so that you would enter into the marriage with them. And it is kind of it's basically a form of control, because when you don't get told the truth about your spouse before you decide to get married to them, they're essentially taking away your control over making a decision based on the facts by yourself, and it's kind of a manipulation to get you into that situation. So also, when you find out at the time of the interview, Maxine, I see your question. I'm going to answer it as soon as I can. Also, when you find out these truths about your spouse at the interview and it comes as a surprise, it doesn't look good, right? Like the immigration officer is going to be like, aha, I got you. You didn't know. So this must be a fake marriage. And your case might get denied as a result. Now, when that happens, again, like I said, when your spouse purposefully hides the truth from you about themselves, about a piece of information that could have influenced your decision on whether or not to get married, that is a classic manipulative tactic, and is usually one of the pieces of the emotional abuse that you may have suffered during your marriage. Now, number two, we have situations where your spouse, you and your spouse might show up at your green card interview, but all of a sudden your spouse forgets the facts, right? They forget how you met. They don't remember what your mom's name is. They don't remember what your birthday is. They don't. They mix up the details, and it makes you guys look like you're in a fake marriage with somebody who you don't even know, right? When your spouse does things like that, that is usually a sabotage on your immigration case. And if you get denied as a result, that sabotage also is a form of emotional abuse. It is a manipulative tactic, and it can form the basis sometimes of us having a successful VAWA case. Now, remember, guys, one more caveat: where one thing exists, it's like the tip of that iceberg, and usually there's more things underneath the surface that you may not even want to acknowledge, you may not want to talk about, you may not want to accept, and that's totally fine. That is why we are here for you, and I just want you to pay attention to these things. Now, the next reason why your green card case may have already been denied by immigration is because your spouse won't give you documents to respond to a request for evidence that they need to help you with. And when you don't respond to that request for evidence, sometimes it is for your husband or for your wife's tax documents or for something else, and they don't give it to you, or it causes you to miss your deadline, Again, like, why would they do that? Why would they do that? Sometimes it is because they're trying to harm your chances of getting approved. And the last reason, one of the reasons why you might get denied on your original marriage case is if your spouse refuses to show up to the interview itself. Now, when your spouse does not show up to the interview, even if you yourself show up to the interview, this is going to pretty much automatically cause you to get denied, okay? So anyway, going back to my original question, can you still file a self-petition even if your original marriage case got denied? And the answer is yes, usually, because what I have seen through my experience on these cases is that usually one of the core reasons why your case might get denied in the first place is because of the bad behavior of your spouse. So where that is true, then we can usually do this. Now, what happens if you had a really bad interview, you had a fraud interview, or they sent one of the fraud inspectors to your house, and you basically get a denial from immigration on your marriage case because they essentially say that you entered into your marriage for immigration purposes, or maybe they might even say that you are showing that you have marriage fraud underneath Section 204C, and therefore that is why they are denying your case. Can you still get a green card through VAWA if this is your situation? Now, here is what I would say. When these are two separate scenarios. Number one, if immigration says that you are showing insufficient evidence to show a bona fide marriage, that is still something that we can explain through the VAWA application, because a lot of times you may not be able to show the traditional forms of bona fide marriage evidence because of the control that your spouse has over your life. But number two, if you actually have an actual finding of marriage fraud, then I would actually ask, number one, does that come from the marriage that you're currently in, or is that from a previous case in the past that you filed 10 years ago, right? If it's in the past, a little bit harder to explain and we may not be able to help, but I would still say to call us so we could take a look at your applications. But if it's from your current marriage that you're in and you yourself know that this is a real valid marriage, then do give us a call because we may still be able to help you, okay? The bottom line is, if your spouse is sabotaging your case, there could be a myriad number of ways that this happens, and it will ultimately affect you and your life, and you do have the power to take that control back and to take matters into your own hand, and you may be able to do that just by filing a self-petition, okay? Call us at 212-248-7907. Hello, and I see a lot of questions. I'm going to be answering them as soon as I can. I want to answer this question from Maxine, who's asking, what about separation during the adjustment of status phase? Maxine, thank you. That is a really important question that you've asked. What happens if you and your spouse get separated during the time that you are doing your green card case together? Now, if you and your spouse get separated during the course of your green card case before you get a decision, that is definitely going to impact your case because this is a joint case that you have done. And usually you have to show that you're in a good faith, bona fide marriage to get an approval. And one of the ways that the immigration officer is going to measure to see if you and your spouse are in a good faith marriage is they're going to ask and try to find out if you're still living together. Now, not living together by itself does not mean that you won't get approved, but most usually, if you are actually separated from your spouse during this time period, there's a very low chance that your spouse is actually going to go with you to the interview and cooperate with you. Moreover, you would have a higher burden of proof almost to prove that your marriage is real, because even if you're separated, you still have to show that you entered into the marriage for the right reasons. So it does become infinitely harder to get your case approved if you are actually separated from your spouse during the green card process. But if you do get separated during your green card process before you get approved, then Maxine, you may actually, depending on what happened in your marriage, you may qualify for a self-petition VAWA application, and you may be able to continue the case by yourself. Okay, so Maxine, I would say to call us at 212-248-7907. Now, why do people get separated, right? Well, marital problems can happen, right? Marital problems, disagreements, miscommunication, all those things happen. But what I would say is this, that by itself is not abnormal. However, When your spouse separates with you or kicks you out or threatens divorce or tells you that they're going to cancel your case and that you owe them because they're applying for you and that's why you should bow down to them every single day, that's not normal. All right. What I would say is that that's not normal. That is not something that you deserve just because you're doing a green card process with your spouse. You deserve to be in a relationship with somebody, in a marriage with somebody who's going to be treating you equally and with respect. But anyway, if this is happening to you, then I would say that those are usually, for me, those are warning signs for a VAWA application, okay? All right, Maxine, I hope that helps. And again, if you do want to call our office for an appointment, our telephone number is 212-248-7907. We do help people all over the US. So even though I am based in New York, we have clients in all 50 states, and we look forward to serving you as best as we can, okay? A consultation is going to be $150. The second consultation from Brightener, just call us back. I'm not too sure what that means. Can we enroll in a university to study while the VAWA case is pending? From VJ, if you have an employment authorization and a social security card, usually you can go to university. That's not something that's a problem for the most part. Hey, Moumita, my VAWA case, I don't know if it's rare, but I filed VAWA from an abusive step-parent when I'm 21. The abuse mostly happened when I'm 17 to 18 years old, and it's been 34 months since I filed and got 5 prima facies. Am I eligible for a green card? From Dimitri. Dimitri Ebanks, thank you so much for your question, Dimitri. I'm so sorry for what you have gone through. Now, if you filed when you're 21, you would no longer be considered a child, but there is an exception for children where you can file for VAWA if you suffered abuse from your parent or your step-parent. If you file between 21 to 25 years of age, as long as you can show that your step-parent's abuse was one of the reasons for your delay, right? Now, Dimitri, it's been taking you 34 months to get approved, and that is actually normal because almost all VAWA I-360 applications are taking an average of 36, 37 months to be approved, regardless of whether it's a parent case, a stepchild case, a child case, or a spouse case. Okay, I would not be worried if I were you, Dimitri. But if you at this point, you can go ahead. You should be able to file an I-485 application. You don't need to wait. You don't always need to wait for your I-360 to be approved to file your I-485. If you need help with that, give us a call, Dimitri. Do I read comments? Sometimes, but if somebody sends me too many of the same comments, I cannot get to all of that. Louise, thank you so much. Can I be deported as an undocumented if I have a T visa pending? From Michael Tete. Michael, so if you have a T visa pending, can you still get deported? And the answer is that it depends on the situation that you end up being in and what state you live in and what official. So for example, if you have an application pending, but then you get arrested for selling 30 grams of cocaine, that you're not going to be protected by anything, by much, okay? Because that is a very, very serious offense. So even if you have a green card, you can still get deported if you get convicted of that. But if you have an application pending with immigration, for me, I think that is always a good thing, because if you happen to be somewhere where you get arrested by an immigration official, sometimes if you show them proof of a pending application, sometimes they will let you out on bond, or sometimes they will release you and they won't do a notice to appear on you. So it really depends. So Michael, it's not a 100% guarantee when you have a T visa pending, but if you have a T visa pending, that means you're going to get a decision within a year or a year and a half, and that is better than sitting there like a lame duck without any sort of protection, if that makes any sense. Okay, Michael. Ridvan, thank you so much. I appreciate that. Okay, let's see. I'm so fast with the phone number. Okay, our phone number is 212-248-7907. And if you follow me on TikTok or Instagram or Facebook or YouTube, our telephone number is always there. It's very visible. Please note that there are people who are impersonating me. There is only one law firm with this name, and there's only one phone number, which is 212-248-7907. We have no WhatsApp. We have no Telegram, and we're not doing wire transfers. So please don't send wire transfers to people that send you a WhatsApp. Can I travel abroad with an advanced parole? From Sammy. Sammy, I love to, I get this question a lot. Now here's the thing. If you have advanced parole, whether or not you can travel is going to depend on your individual circumstances. Because one of the first things that I would say is that if you have any criminal history at all, I believe it's better to not travel at all, because you will have to go through border patrol. You will be put aside into secondary inspection and asked questions. And any flag that comes up on your name can create a problem with the Customs and Border Patrol agent. So generally speaking, if you want to travel with advanced parole, please talk to your attorney, not me. Please talk to your attorney on your case to clear it with them and follow their recommendations. Okay. Why is my I-130 I485 taking so long? 348 days, and I'm still waiting from Mama Shark. Mama Shark, that's less than a year, and that's not so bad. I would say your I-130 I485 can take anywhere from 6 months to a year and a half, depending on your location and also what your category is sometimes, and also depending on whether immigration wants to give you an interview at the office. Does expedited VAWA give you a yes or no to residency or the work permit? From Susie. Susie, if you expedite your I-360 VAWA application, it will expedite a decision on that application and get you a new work permit underneath the C31 category and move you into that phase of your case for the green card. So you have to get your I-360 approved first before your case can move on to that I-485 green card stage. So it does help move it along faster to that destination. However, it doesn't get you exactly to that stage directly to the green card by itself. Sajad, one of my friends got the waiver of his green card because he never disclosed his first marriage in his country. Now my question, can he apply for citizenship after the waiver is approved? Look, if anyone here has committed misrepresentation of some sort to immigration to get the green card, I don't know. I just, when you apply for citizenship, they can ask you all sorts of questions and they can ask for all sorts of evidence all over again. And you run the risk of having your previous fraud be discovered again. So I can't answer that question. And all I would advise anyone to say is that all I would advise anyone to do is to always tell the truth when you apply for these applications. Hello, Gabby. Time flies. It's been almost 2 years since my VAWA was sent. Because of your firm, I am the attendance registrar at an elementary school. Love my job. Gabby, thank you so much for the update. You are a true hero. You are a true success story. I'm so touched and pleased to see where you are right now. I know that having a job like this was one of your dreams. So congratulations, Gabby. Time's going to fly even faster, and we're going to be getting to your approval and to your green card in no time. Okay. Besos y abrazos a usted. Okay. All right. Let's see. Can I join the military with a conditional resident green card? From Alec. Alec, I actually don't know the answer to that question. Can I help my brother-in-law become legal since my sister won't? From Sai-V or XAIV. Interesting question. So can you help your brother-in-law become a legal resident since your sister, who's presumably a U.S. citizen, won't? And Sai or Xavier, I'm so sorry. Whatever your name is, if you have a family member who you know is married to a U.S. citizen, who you know is not helping them get a green card, then you really should have that family member call us, because even though you may want to help, really it's going to be very difficult for you to help a brother-in-law or a sister-in-law, but they may be eligible to do a self-petition on their own, and that is going to be their golden ticket out of the situation that they're in, okay? So call us at 212-248-7907. What is the processing time for the T visa? It is about 1.5 years is what we're seeing these days. Spoonman is asking him to marry me. I'm so sorry. I will not. I am married for 14 years. And I also just feel like that's incredibly creepy too. All right. Let's see. In what cases is a biometrics waived for H4 EAD standalone application? I'm not too sure. Sometimes if they already have your fingerprint on file. Leslie is saying, we started dating when I was 12 and he was 19 and now we're 18 and 24. Would that complicate the case? From Leslie, well, Leslie, I think that the age difference may be problematic underneath state law, criminal law, but if you're 18 and 24, can you do a case? Usually, you just have to satisfy the regulations for filing for a case, and usually you just need to be legally married. You just need to be the age for legal marriage in your state, and that's what it's governed by. What is humanitarian parole? From Arusa Karim. Arusa, a humanitarian parole can be a couple of different things, but generally it basically means that you're either being allowed into the country or you're being allowed to stay in the country because of some urgent humanitarian reason. It's very discretionary. For example, let's say you're outside the US, but you have a family member who just died tragically inside the US and you need to come in to take care of the funeral or the remains. You can ask for humanitarian parole to be allowed in if you don't have a visa, and a Border Patrol agent would usually make that decision. Ridwan, God bless your hard work. I got my VAWA expedite approved in January, but no medical yet. What are my chances and how long can I get approval? Ridwan, look, your chances are probably going to be very good. If your expedite got approved, you still have to wait for the I-360. Your EAD, your VAWA expedite, it's coming. Hopefully you'll get that within approval within a couple of months. And after that, it will take between 6 months to a year for that green card process. The initial consultation is $150. And if we cannot find a case for you, if we cannot help you, then we would actually give you a refund if we can't take your case. Suman, I called many times, but your staff who's receiving the phone calls are so arrogant and unprofessional and showing attitude. Suman, I'm going to ask you a question. Are you demanding to speak with me or demanding to have an appointment with me? Because a lot of times people, Suman, it sounds like maybe you're from Bangladesh, you're from my country, and a lot of what I've noticed is a lot of people from my country want to speak directly with me, which is not the way that we work. But if you are unhappy with how we've done your call, please call again and ask to speak to the manager so we can review your call to see if there's any violations of process done. Yeah, exactly. You're saying can't even make an appointment to talk with me. Yeah, but my love, if we tell you that our process is not to speak with me, I'm not going to give you an appointment to speak with me because that's not how we work. But if that's how you want to operate, there's lots of other attorneys that will do that and they will speak with you directly. Unfortunately, that's not me because I don't have the ability to do that, but it's also not my process. So I also feel that it's unfair for you to call my staff rude when we've told you that's not what we do and you're demanding yet to speak with me, okay? But good luck. Ash, I was able to see my family twice with Advanced Parole, of course, with the help of your firm. Thank you so much again. Ash, you're so welcome. I'm so glad you got to see your family. That's a blessing. I'm very happy for you. Thank you for trusting us, Ash. Let's see. Sajjad, thank you so much. Oh, Sajjad, thank you so much. I really appreciate that a lot. How long do I have to wait for a work permit from Mandy? Mandy, I would say work permits usually take an average of 6 months to 8 to 10 months, depending on the type of category that you are filing for. Would I know if my husband reported me out of anger to USCIS from EC Cassider or ECE? So good question. If you're doing a marriage case with your spouse and you know your spouse has a habit of getting angry and threatening to report you, how would you actually know if your spouse has reported you? And the answer is actually that you would not know. You would not know if your spouse has actually reported you to immigration out of anger, accusing you of having committed marriage fraud. But if your case ends up having a lot of pushback, a lot of trouble, that could be one of the things behind it. Now, if you are afraid that your spouse has reported your marriage as being fake, then look, that's a sign that you should probably not wait around any longer, and you should probably explore your options for a self-petition. So we would be very, very happy to talk to you. Call us at 212-248-7907. What are the pros and cons of marrying a green card holder while I'm out of status? From Renee, First Lady. Renee, thank you for your question. So if you are out of status and you marry a green card holder, there's not really a con to it per se, because they can still file an I-130 for you. And in the future, you may still be able to get a green card, but it would be more difficult, because if you are out of status and your spouse is only a green card holder, then you need to have a waiver for unlawful presence, and you may need to leave the US to do an interview at the consulate in your country. Now, here's a couple of ways around that. Number one, you can get married and have your spouse file an I-130 for you, but instead of doing the waiver, you can also wait for them to do their citizenship. Okay, that's option one. Or number two, if you are undocumented, out of status, and you are married to a green card holder, if you have been having marital problems where your spouse has made your life very difficult, then you may be eligible to do a self-petition instead through VAWA. And when you are an out of status spouse of a green card holder and you do VAWA, you do not need to leave the US to do your green card application. You simply have to wait until your priority date is current on the visa bulletin to submit your I-485 application. However, that does not affect when you can file your I-360. So you'll still be on your way to getting a green card a lot more easily, usually, than leaving the US with the waiver. Nick, thank you for the follow. What happens if we respond to an RFE 3 weeks after the deadline? From Zalani. Zalani, if you miss your deadline, then generally you will, thank you, Nick. Thank you, Nick, for the roses. Sorry, got distracted. If you respond to an RFE after the deadline, then usually that means you'll probably get denied. Now, sometimes you can move to reopen a denial if you have a good reason why you didn't respond on time. But sometimes it might mean that you need to start your case over again. I applied for my husband and my case category is, let's see, is F2A and more than 1 month. I'm still not allowed to pay IB form. How long will it take? You have to wait for your priority date to become current, Rehan. I have DACA and I own a business and I want to get advanced parole, but I'm scared to not get let in. From AG 1820. AG 1820, I understand the fear, again, whether or not you should travel on advanced parole, for me, highly depends on your criminal background and history. We have done DACA advanced parole for many people, and they've come back in with no problem. We'd be happy to talk to you and walk you through the process to see if there's a problem or not. And if you have DACA, but you don't have a legal entry and you've been thinking about doing advanced parole, now is the time to do it, guys. Now is the time. I don't think that you want to wait to try to travel, who knows what's going to happen with DACA, especially, if we end up having Trump as the president again, okay? So call us, AG 212-248-7907. V. Parkinson saying, I would like to do a consultation with me. V. Parkinson, I just want to explain one thing for those of you who are calling us and who want to make an appointment with me. The appointment, when you call our office at 212-248-7907, you would be making an appointment with my legal team, my special intake team, and they will be talking to you and asking you questions to see how we can help you on your case. They are specially trained by me very, very carefully, and we work together to see how we can help clients. So you would actually not be having a consultation directly with me, but with my team. But don't worry, we do things very carefully, and you're still going to get an amazing level of service that you won't get at any other law firm, okay? All right, everybody. Actually, I'm going to ask answer one more question. Will I lose my EAD if my husband withdraws my I-130? I-485 is pending in status for interview from Jyoti. Jyoti, if your spouse withdraws your I-130, you may not lose your EAD right now, but your I-485 may get denied, and at that point, you would not get your EAD. Again, if your spouse is withdrawing your I-130, or if they're withdrawing your case, they're trying to harm your chances of, they're trying to interfere with your chances of getting your green card. These are controlling, abusive, manipulative tactics, and you should not delay in exploring what your options are to take control back into your own hands, okay? So call us at 212-248-7907. All right, guys, that's all the time that I have for tonight. Thank you so much for joining me. I hope you all have a wonderful evening. Please do me a favor. Please follow me anywhere you see me on social media, on YouTube, on TikTok, wherever. And please share my videos with anyone who you think they might help, okay? And for an appointment, call us at 212-248-7907. I hope you have a wonderful evening. Take care.